What we'll be looking at today is I will introduce you to what politics means. That's what theories means, what legal means. We'll be looking at the meaning of political and theory separately. We'll also look at the nature of political theory. Now, there's what we call political theory. We also have legal theory. Now, legal theory can be legal psychology, depending on how it's being used. But let's start with the meaning of political theory, then we'll move from there. Now, theory means the activity to understand whatever is happening around us. While political theory is the study of how we ought to organize the forces that shapes our lives. I'll repeat myself. Now, the word theory is gotten from a Greek word, which means to understand the happenings, whatever is happening around us. You understand? Why political theory is to organize, means to organize, or how we ought to organize the forces that shapes our lives. Now, hope we know that there are forces that shapes our life. There are forces that command our activities, like the government, the people in authority. Those are the forces. Now, let's look at the nature and significance of political theory. Politics is a specific area which is different from other areas. It's different from economics, it's different from society, it's different from culture. Even then, for the last decade, there has been an increase in the dissatisfaction about the assumption of the politics, as in how they influence their power over us. Now, in other words, they are not able to manifest the beliefs of politics. Political theory is a combination of both political science and political philosophy. Now, where science indicates towards the various facts of the process to control the entire social life. Now, it is related to the political philosophy. It is what is good for the nation. Now, political theory is designed in such a way that it benefits the nation. Now, what is a good society? A good society is any society that has a good political theory and legal theory. Philosophy of law or legal theory is concerned with providing a general philosophical analysis of law and legal institutions. Issues in the field range from abstract about the nature of law, about legal system. It also looks at the relationship between law and morality for various legal institutions. Now let's look at, there are three main jurisdictions of legal study. The first is the jurisprudence. We have the analytic jurisprudence, we have the feminist, we have the tradition. But let's quickly look at the analytic jurisprudence, which is the principle or the principal objectives, as in the tradition to provide an account of what differentiates law as a system of norms from other systems of norm, such as ethical norms. Now, analytic jurisprudence seek the essence or the nature which is common to all laws that are properly so called. Now, it looks at the essence or the nature of all laws, and it looks as a common ground on how to base its theory. Now, the tax, why this tax is usually interpreted as an attempt to analyze the concept of law and legal system. There are also some confusion as to the value, as in the value and character of analysis. Now, Brand point out analysis as its principal concern. You understand? Brand looks at analysis or philosophy of law as one of the few disciplines that takes analysis as its principal concern. To clarify the role of analysis in law, Bryan also distinguished a number of different purposes that can be served by conceptual claims. It looked at in the track to track linguistic usage, to stipulate meanings, to explain what is important or essential about a class of objects, to also establish an evaluative test for the concept word. Now, in all events, let's not forget what we are talking about, which is the political theory or legal theory. You really have to do a lot of reading, a lot of assignments on this course. Now, in an event or conceptual analysis of law remains an important part of the theory of legal study. Conceptual theory of law can be divided into three or two main headings. Those that affirm there is a conceptual relationship between law and morality. Those that deny that there is such a relationship, as in there is no such relationship between them. Those are the two controversial projects or controversial legal theory. A legal theory that talk about the relationship between law and morality, that there is a relationship between law and also morality, that law shapes the way people behaves, law shapes the way people think. If we look at remember the meaning of political theory, it's talk about or it focuses on the on how to organize or shapes our lives. So conceptual law legal theory looks at two main things and two main controversy which talk about their relationship, the relationship between law and morality, and the other part denied that there is no such relationship. You understand that law is not related, it doesn't base a law is not based on morality. Now, nevertheless, Ronald view is often a third theory because it is not clear whether it stands on the question of whether there is a conceptual relationship between law and morality. Now, legal theory um, also looks at the natural law, which is the natural law theory. It talks about all forms of natural law, which is that there is necessary relationship between the concept of law and morality. Now, according to this view, the concept of law cannot be fully articulated without some reference to moral notion. Though the overlap may seem obvious, there is a number of different ways in which it can be interpreted. That is, there is a number of ways law can be related to morality. Now, there is this belief that before a law is given, the society should come in view. Now, a law cannot be given without bearing the society in mind. The natural law also looks at it's also the binding over the globe, that's over the nation in all countries and at all times. No human's laws are of any validity if contrary to this. Now, according to the view, the concept of law cannot be fully articulated without some reference to moral notions. Now, but Lon Fuller rejects the idea that there are necessary moral constraints on the content of law. On Fuller's view, law is necessarily subject to a procedural morality consisting of 8 principles. The first principle says the rules must be expressed in general terms, that all rules of law must be expressed in general terms. The second one says the rules must be public promulgated, it must be publicized. Now, the third one says the rule must be prospective in effect. You understand? The rule must be expressed in understandable terms. The rule must be consistent with another. The sixth one said the rules must not require conduct beyond the power of the affected party. The last one says the rules, or the seventh rule says the rules must not be changed so frequently that the subject cannot rely on them. Finally, it also states that the rules must be administered in a manner consistent with their consistent with the effect. Now, the rules must be expressed in general terms that is understandable. The rule must be publicized or promulgated, public promulgated. The rules must be prospective in effect. It must be expressed in an understandable terms. The rules must be consistent with one another. Now, Fuller view also looks at to satisfy these principles of legality. It also looks at achieving social order through the use of rules that guides behavior. Now, a system of rules that fails to satisfy the rules must be public promulgated, or the rules must be expressed in understandable terms. Any system that fails to understand it or to satisfy this cannot guide behavior, because people will not be able to determine what the rules require. Now, according to Fuller, he concludes that his 8 principles are internal to law, in the sense that they are built into the existing conditions for law. A total failure in any one of these 8 directions does not simply result in a bad system of law. It results in something that is not properly called a legal system. Now, Fuller looks at these main rules, that's rule number 2 and rule number 4, that the rules must be publicly promulgated and the rules must be expressed in an understandable terms before it can be termed as a legal law or a natural law. Now let's go forward. We have legal positivism. Now, this opposes all forms of naturalism, which is roughly constituted by 3 theoretical comments: the social fact thesis, the conventional thesis, the separability thesis. Now, the social fact thesis, also known as pedigree, asserts that it is a necessary truth that legal validity is ultimately a function of certain kinds of social facts, while the conventional thesis emphasizes law's conventional nature, claiming that the social facts giving rise to legal validity are authoritative in virtue of some kind of social convention. The separability thesis is the most general level, simply denies naturalisms. According to separability thesis, there is no conceptual overlap between the notions of law and morality. Now let's look at the 3 legal positivism. The first is the conventionality thesis, the social fact thesis, and the separability thesis. The conventionality thesis is a conception, or it looks at truth about a law. Now, it's a conceptual truth about law that legal validity can ultimately be explained in terms of criteria that are authoritative in virtue of some kind of social convention. For example, Hart believes that the criteria of legal validity are contained in a rule that sets forth for creating, changing, and adjudicating law. On Hall's view, their rules of recognition is authoritative standard that governs their behavior as officials. Now, the social fact thesis asserts that legal validity is a function of certain social facts. They also urges that the principal factors or features of a legal system is the presence of a sovereign who is habitually obeyed by most people in the society, but not in the habit of obeying any determinate human superior. Now, the social factor thesis confirms that for one kind of rule, primary rules that requires or prohibit certain kind of behaviors. Now, social fact thesis also looks at the 8 principles of rules in terms of general terms, expressed in general terms, expressed in understandable terms, must be consistent with one another, must not require conduct beyond the powers of the affected parties. The rules must not be changed so frequently that the subject cannot rely on them. The rules must be administered in a manner consistent with their wording. Most importantly, however, the existence of secondary rules that have as their subject matter rules out that the primary rules themselves are different or full-blown legal systems from primitive systems of law. Now let's look at the primary rules and the secondary rules of law. The primary rules of law overlooks the existence of the secondary rules. The primary rules are the main rules, which are the 8 rules of principles, 8 principles of law. While the secondary rules while the secondary rules may all be said to be on a different level from the primary rules, for they are all about such rules, in the sense that while primary rules are concerned with the actions that individual must or must not do, secondary rules are all concerned with the primary rules themselves. So they specify the way in which the primary rules may be conclusively ascertained, introduced, eliminated, verified, and the fact of their violation conclusively determined. Now, the primary rules is concerned about the actions of individual, what an individual should do, what an individual should not do, while the secondary rule is concerned about the primary rules, how it should be carried out, how it should be decided, how it should be introduced, how it should be eliminated, and the factors of their violation, how it should be determined. How to distinguish 3 types of secondary rules that mark the transition from primitive forms of law to full-blown legal system. The rule of recognition, which signifies or features possession of which by a suggested rule is taken as a conclusive affirmative indication that is a rule of the group to be supported by the social pressure, which is the first one. The second one is the rule of change, which enables a society to add, it enables a society to modify or remove rules. While the third one is the rule of adjudication, which provides a mechanism for determining whether a valid rule has been violated or not. We have the first one, the rule of recognition, the second one, the rule of change, the third one, the rule of adjudication. Now, Hobbes views every society with a full-blown legal system necessarily has a rule of recognition that articulates criteria for legal validity that include provision of making, changing, adjudicating law. Law is to use famous frame, the union of primary and secondary rule. Now, the primary and secondary rule can be said they work hand in hand, because while the primary rule is looking at how an individual what an individual should do, stating what an individual should not do, looking at the 8 principles of laws, that a law must be understandable enough, it must be consistent with one another. It must be expressed in general terms. It must not require conduct beyond powers of the affected party. The secondary rule looks at how the primary rules can be introduced, how the primary rules can be eliminated, how it looks at what factors should determine the violation, that is anyone that violated the primary rules, what are the factors that determines their punishment and the rest. So there's a union between the primary and the secondary rules. Now let's look at the separability tests. The final thesis, which is the separability thesis, comprising the foundation of legal positivism, is the separability thesis, and it is in its most general forms. It looks at the law and morality. It looks at it asserts that law and morality are conceptually distinct, that they are different. The abstract formulation can be interpreted in a number of ways. For example, it interprets it as making a meta-level claim that the definition of law must be entirely free of moral notion. Now, it also implies that any reference to moral consideration in defining the related notion of law, legal validity, and legal system is inconsistent with the separability thesis. More commonly, or the separability test is interpreted as making only an object-level claim about the existence condition for legal validity. As Hart described, the separability test is no more than the simple contention that it is in no sense a necessary truth that law is reproduced or satisfies certain demands of morality, though in fact they have often done so. Uh, Insofar as the object-level interpretation of the separability thesis denies it is a necessary truth that there are moral constraints on legal validity, it also implies the existence of a possible legal system in which there are no moral constraints on legal validity. Though all positivists agree that there are possible legal systems without moral constraint on legal validity, there are conflicting views on whether there are possible legal systems with such constraints or not. According to positivism, rule of recognition is to incorporate moral constraints on the contents of law. Now let's go to the next jurisprudence, which is the normative jurisprudence. It involves or normative, it evaluates and otherwise prescribe questions about the law. Here, we will examine three key issues. We'll look at three key issues. What and to what extent laws can restrict the freedom of citizens. Now, the nature of one's obligation to obey the law and the jurisdiction or justification of punishment by law. Normative jurisprudence looks at or evaluates the questions about what and what extent can law restrict an individual or the freedom of individual. The law can restrict the freedom of individual so long the individual understand the rules of law, he understand and the commands of law, he understand what law is all about. That's why the eighth principle of law states that a law should be understandable enough. A given law should be understandable enough. Now let's look at the freedom and the limits of legitimate law. Laws limit human autonomy by restricting freedom, which is true. Currently, there is a rule of law that says everybody should stay at home. There should be no movement unless if it is necessary. You must have a permit before you can go out. If not, you'll be arrested. So technically, the law has restricted our freedom of movement. So freedom and the limits of legitimate law. Laws limit human autonomy by restricting freedom. Criminal laws, for example, remove certain behaviors from the range of behaviors option by penalizing them with imprisonment and in some cases death. Likewise, civil laws require people to take certain precautions not to injure others and to honor their contracts, given that human autonomy deserve primal moral respect. The question arises as to what are the limits of the state's legitimate authority to restrict the freedom of citizens. John Stout provides the classic answer in the forms of the harm principles. The sole end for which mankind are warranted, individually or collectively, in interfering with the actions or the liberty of action of any of their numbers is self-protection. The only purpose for which power can rightfully be exercised over any member of a civilized community against his will is to prevent harm to others. Now, every individual is obliged or is expected not to put people in harm's way. Why? Because the way they live, the way they operate their business should not put an individual in harm's way. That's the civil law. His own good, physical or moral, is not a sufficient warrant over himself, over his own body and mind. The individual is under law. Now, freedom and the limit of legitimate law states that every human being is restricted. The law is power enough to restrict an individual freedom. Now, under criminal laws, a criminal law can state that an individual is guilty and can be imprisoned. It can give 20 years imprisonment, 6 months imprisonment, depending on the extent of the crime. And it can also lead to death, either death by hanging or any other form of death. So the question that says that when and to what extent can a law restrict an individual, the freedom of individual? It can restrict the freedom of an individual. The law can restrict the freedom of an individual depending on the issue at hand. Let's move on to legal moralism. Legal moralism is the view that the law can legitimately be used to prohibit behaviors that conflict with society collective moral judgment, even when those behaviors do not result in physical or psychological harms to others, which is true. A law can state that any citizen should not be allowed to smoke in a public place. So it's restricting the behavior of an individual within the society. So it's not as a result of physical or psychological harm to others. You understand? So a law can restrict the behavior of an individual. According to this view, a person's freedom can legitimately be restricted simply because it conflicts with society collective morality. You understand? Thus, legal moralism implies that it is permissible for the state to use its power to enforce society collective morality, which is true. In some universities, especially in the north, there is a limit to how a lady would dress. Even there's a limit to how a guy should dress. There's the rules and regulation guiding the conduct of the people, of the students within the school. You understand? Before a student will be allowed to enter the school premises, you should dress in a normal way, in a matured way. You understand? There are some certain type of dresses that are not allowed, they are not permitted. So a law can restrict an individual because of the society collective morality. It's trying to protect the morality of the society. Thus, legal moralism implies that it is permissible for the state to use its power to enforce society collective morality. The most famous legal moralist, which is Patrick Devlin, who argues that a shared morality is essential to the existence of a society. If men and women try to create a society in which there is no fundamental agreement about good and evil, the society will fail. If having based it on common agreement, the agreement goes, the society will disintegrate. For society that is not something that is kept together physically, it is held by the invisible bonds of common thought. If the bonds were too far relaxed, the members will drift apart. A common mankind which needs society must pay its price. So an individual must pay the price, which is the law. An individual must abide with the law of the society. Insofar as human beings cannot lead a meaningful existence outside of society, it follows on Devlin's view that the law can be used to preserve the shared morality as a means of preserving society itself. And finally, let's look at the offense principles. The offense principles. Joel believes the arms principle does not provide sufficient protection against the wrongful behaviors of others, as it is consistent with many criminal prohibition. We take many criminal prohibition we take for granted as being justified if only legality or legitimate use of the state force is to protect people from harm caused by others, then statutes prohibiting public sex are impermissible because public sex might be offensive but it does not cause harm to others. Accordingly, Feinberg argues that or urges the harm principle must be augmented by the offense principle, which he defines as follows. It is always a good reason in support of a proposed criminal prohibition that it would probably be an effective way of preventing serious offense. Now, the arms principle looks at um, the arms principle does not provide protection against wrongful behaviors because it only looks at any act that an individual does to or any act that an individual do to others that can cause harm. So, but there are different levels of harm. That is, it can be direct, it can be indirect. You understand? It can cause a direct harm, it can cause a psychological harm. Like the case of public sex, the harm principle doesn't see it as anything because it does not cause an harm to others, any harm to others. It does not cause any risk to others. But the offense principles looks at public sex as an offensive to others, an offense to others. Indirectly it can harm others either psychologically, emotionally, morally, and the rest. So he also urges that the harm principle must be amended and should be well defined. It also look at a good reason of support to a proposed criminal prohibition that it will probably be an effective way of preventing serious offense. So to a person other than the actor, and it's probably a necessary means to that end. Feinberg intent a subjective and objective element. That is, the subjective element consists in the experience of an unpleasant mental state, for example, shame, disgust, anxiety, embarrassment. The objective element consists in the existence of a wrongful case of such a mental state. The difference between the arms principle and the offense principle is that the arms principle always look at any crime that causes harm to people. Yeah. So any harm that does not cause any crime or any harm to people is not acceptable. It cannot the hands of law cannot the individual cannot be prosecuted because it doesn't cause any harm to people. But the offense principle looks at any type of criminal or any type of offense that can affect an individual psychologically, emotionally, morally is a harm. So it can be the individual uh, can be arrested, the individual can be sentenced to any form of jail. Now I'm going to end the class now. The assignment says discuss the following: the obligation to obey law, the justification of punishment, the critical theories of law. You have to submit it through my private email, bimselai@yahoo.com. Thank you for your time. We'll meet same time next week. Bye.